again, for anyone who missed my name, I'm Katherine Sandoval, and I'm the managing partner in our California office of Matthiesen, Wickert, and Lehrer. So again, this is going to be all about California medical payment, MedPay reimbursement. I will try to dabble a little bit at the end in some other states if I have time. And I really wanted to focus in on California MedPay reimbursement because in my opinion, it is a truly forgotten subrogation recovery. So let me briefly take you through what we're going to be discussing today regarding MedPay. Well, we're going to talk about what is MedPay. When is MedPay actually paid? To whom is MedPay paid to? We're going to talk about giving out proper notice regarding MedPay reimbursements. We're going to talk about a good amount of time too, as well as on litigating the MedPay reimbursement claims. I really want to dive into how the litigation process works in California because it's one of those complicated, nuanced litigation states. We're also going to talk about common defenses that I've come across during my practice of medical pay reimbursement. And then, as I said, if time permits, we're going to discuss some other states and their views on MedPay reimbursement. All right, well, let's dive on in. So, automobile subrogation is extremely important, especially when people are now returning to the roadways, especially with California, which has just opened back up. In the last 2 days that I've been on the road to work, I've actually seen horrific car crashes. I saw a car that was rear-ended and it was sent through an actual retaining wall into a pool. And as you can imagine, California had a tremendous amount of rain, and us Californians, I have to admit, aren't the best drivers on the rain, so there was lots and lots of accidents. But there's 275 million cars in the U.S., more than any other country. There's over 7 million auto accidents in the U.S. annually. And that's a financial toll of $300 billion. And then there would be 3 million people that are injured in the United States. So on average, there's about 4,500 people that are killed. That's 115 per day. And if you think about that'll be 10 that will unfortunately pass away during this presentation. So there is actually $70 billion in annual passenger auto liability claims. And with that in California is MedPay. So recovering back on these claims makes it's so important if you're just looking at the sheer numbers that I just spoke about. And so again, why are we talking about this? Well, MedPay is tied to auto, and we're going to go in depth about that shortly. So I'm going to briefly just discuss automobile insurance coverage in California to give a broad overview. There is liability coverage, which include bodily injury and property. California does have this requirement that at a minimum to carry liability insurance of $1,500 per person, $30,000 per accident, and $5,000 for property damage. There's also medical payments, which is MedPay, which is what we're here to talk about today. And it's available in California, but it is not required. However, many policies are going to contain an optional MedPay coverage provision. Usually the coverage is somewhere around $5,000 to $10,000. You also have a personal injury protection, PIP, but that's not available here in California. And then you have the uninsured, underinsured, UM/UIM. No policy of automobile liability insurance is allowed to be issued in California without provisions for uninsured motorists UM coverage with policy limits that are equal to the bodily injury. There is a couple ways around that coverage that the insured and insurer can do. You can delete the provision covering damages caused by a vehicle completely. You can delete the coverage when a motor vehicle is operated by a person designated by name, or you can agree to provide coverage in an amount that is less than the liability limits that are required. But this all has to be agreed to in writing. There's also collision and collision comprehensive coverage. Subrogation of auto collision claims is permissible in California. Most policies contain terms which define the limit of damages the carrier is going to owe in the event of damage to that insured vehicle. Normally, damages are calculated as set forth in California law. We look at reasonable repair. We also will look at cash value versus replacement value. So, an insurer's right of subrogation does not depend on any express subrogation language contained in an insurance policy. It inherits the insured's rights automatically by law. But there are three types of subrogation that I want to talk about. So it's contractual subrogation, equitable subrogation, and statutory subrogation. Contractual subrogation is known as conventional subrogation. It's based on contract between the parties. You're looking at the subrogation language in the policy. We'll talk about this at length, but this is where, for California purposes, MedPay subrogation comes about. There's equitable subrogation, also known as legal subrogation. It is a product of equity, and it's not dependent on any contract, assignment, or privity. It does arise by operation of law out of fairness due to the fact that one person has been compelled to pay the debt which should have been paid by another. And then there's also, again, statutory subrogation. It's granted by state and federal legislation. This is a lot of workers' compensation, hospital lien, Medicare. It will involve PIP and MedPay in certain states. So in California, statutory subrogation has been relegated to statute of equitable subrogation, which makes it subjected to equitable defenses such as the made whole and common fund doctrine, which we will go into length about. So the purpose of subrogation is going to be to prevent the insured from, one, obtaining that double recovery, which is so key in MedPay claims. It places the responsibility for paying loss on a party who caused the loss, and it really holds down those insurance premiums. All right, well, what is MedPay? It pays for the medical expenses of an insured and his or her passengers after an accident. Coverage generally includes accidents which occur while an insured is driving someone else's vehicle with permission, or injuries to the insured or his or her family members while they are pedestrians. As I mentioned earlier, this is an optional coverage that can be chosen on automobile policies in California. In California, as we were discussing, MedPay is a contractual subrogation, and it's really known here as a contractual reimbursement because MedPay in California is policy driven. If a carrier does have the medical payment option in their policy, but does not have anything in the policy that's written regarding reimbursement of the MedPay, then that carrier will not have any reimbursement rights. And who is this contractual reimbursement with? Well, that is with your own insured, which you will see later on is why sometimes this tends to be a tricky or sticky subject in terms of going after reimbursement, as your only recourse is going to be to go against your own insured. So again, the policy is between the carrier and the insured, which creates this contract. So California MedPay, you're entitled to reimbursement rights only, and that's very important to know. and it's based on policy provisions authorizing the same, provided that the insured has been made whole with regard to non-covered damages, not including attorney's fees. And again, we will look into that in depth. There is no intervention allowed in California. There is no direct subrogation allowed for MedPay because assignment of personal injury actions is just not allowed. So let's take a look at exactly what I am talking about. Okay, so let's look at these two policies right now. Section A says, if we make a payment under this policy and the person to or for whom payment was made has a right to recover damages from another, we shall be subrogated to that right. Now let's look at B. If we make a payment under this policy and the person to or from whom payment is made recovers damages from another, that person shall, 1, hold in trust for us the proceeds of the recovery, and 2, reimburse us to the extent of the recovery. So these are two written reimbursement languages that can be found in a policy. You will notice that one is more general than the other. The more specific the reimbursement language, the less likely it will be challenged in a court setting. The more vague or general that it is, it's going to be attacked. So if you look at A, you can see that it states that if the insured receives any type of recovery, they need to reimburse the carrier. But if you look at example B, or number B, it also has this language regarding holding it in trust. And when you put the insured or their attorney on notice, you want to quote that language and make sure they need to hold that disputed fund in trust until our claim has been resolved. And this is really, really important because once a counsel is put on notice of a lien, they are required by the California State Bar to hold that disputed amount in trust. And if they don't, they're actually going to be breaching ethics codes and potentially could be reported to the State Bar by their client, by the opposing attorney, and even by the court. So let's talk about who MedPay gets paid to and how is it paid. So as I mentioned earlier, again, this is a contractual reimbursement. So this is all based on how it is written in the policy. You can see policies that say that the med payments will be paid directly to the insured. So the check is cut directly from the carrier to the insured. Some policies will have the payments go directly to the doctors. I've also seen policies where the adjuster can make the decision as to who to pay, either the insured or the doctor. And many of the med payment policies will also have language to the effect that says the carrier is only going to pay for services that were reasonably necessary. Well, one would wonder who makes that determination of what's reasonably necessary, and that would be the carrier upon review of the entire claim file, the accident, and any other documents that they need to review. This language about who gets paid and how it is paid is become a major sore issue with plaintiffs' counsels who are representing the insureds in these third-party bodily injury actions. All right, we are at polling question number 1. California MedPay reimbursement rights are contractual. True or false? I'll give you guys just a little bit of time to answer that poll question. All right, I have about 88% of you in, so it is true. And 90% of you said that. So we've discussed what MedPay is, how it is paid, and to whom it is paid. So how do we get to reimbursement? Well, it all starts with the notice element. A carrier once informed that an accident has occurred by their insured should immediately have notice letters going out to the insured regarding the medical payment benefits that the policy has, and if they want to decide to use them, that there is this reimbursement clause. So from the outset, you are telling them there is a reimbursement clause in the policy. There's many times that an insured will state that they've never received these notices, but as long as you can show that it was addressed correctly, it will be deemed that the insured received notice. You also should not just send that notice once. I actually recommend that you want to continually remind the insured that they have this clause of reimbursement. Usually, I recommend sending notices out on a monthly or even a 60-day basis. You should also send out notices to anyone that was involved in the accident that the carrier winds up paying MedPay to. And well, why is that? Well, as we will see later on, you do not need to be the policyholder to owe a reimbursement to the carrier. As long as the carrier has paid out the medical payments, they need to reimburse you. As long, of course, as there's that clause in the policy regarding reimbursement. Now, most insureds or the passengers at some point will retain counsel. So you should immediately send these notices to their counsel. And in fact, once you know they're retained as counsel, you only can direct your communication to counsel. And you would actually think that the insureds are bad about claiming that they've never received the notice. But I will tell you, I think I've heard it more from attorneys claiming that they've never got these letters from the carrier. They never knew they had to be reimbursed. But again, as long as we have the properly addressed letters, it will be proper notice. Again, in my opinion, giving more notice than not doesn't hurt the carrier's position when it comes time to be reimbursed. So let's get this all teed up. The insured obtains an automobile policy. They select that they want medical payments as part of their coverage in the policy. They proceed to get in an accident. The carrier starts to give, the carrier pays out the MedPay. Then the carrier starts to give out notices about reimbursement. They go unanswered. They go ignored. The carrier then receives a notice from the insured's counsel, let's say, about representation. So then we proceed to send the notices right to the insured's counsel. Nothing is working. You're getting silence. Well, this is when the carrier can decide enough is enough. And you can retain counsel or you can keep pursuing in this pre-litigation fashion. I'm going to pretend that we've retained counsel because I am counsel. So the next step in this process is going to be trying to resolve the matter in what's known as the pre-litigation process. It means prior to ever having a suit filed and prior to ever going to a courthouse. Usually you'll have that notice of representation will go out to plaintiff's counsel from me. And then I will cite the language of the policy. Sometimes even adding the excerpts pages from the policy. And then I always will demand to be informed if a third-party settlement has been reached. In these letters, it's always a good idea to provide a deadline to respond, because if counsel thinks they have this open-ended deadline, they won't respond, I'll tell you that much. I've also found that it is a really good idea to send the letter to the insured or the policyholder, even if they weren't involved or received any payments. So just so that they're aware of what's going on in their own policy. And as I said, the named insured may not be the one who got the benefits of that medical payment. It could have been that someone who was approved as an additional driver was driving, or maybe there was that passenger in the vehicle that isn't part of the policy. One too far. So you have put all the appropriate parties on notice. Well, now what? And this is where the fun begins, in my opinion. So I always will keep track of all the notices that are sent to all the parties, because as I said, the insured or the passenger or their counsel is going to claim that they, number one, never, ever got any of these notices. So therefore they never had an idea of what was in the policy. They never knew it had to be reimbursed. And these notices, keeping track of them is going to be very useful if we have to get into suit. You also want to keep track of when the settlement has been reached. And why is that important? Well, again, a carrier can only get reimbursed upon the insured reaching a third-party settlement. So we need to know if we need to be waiting and monitoring until there is a settlement, or proceeding with the claim if there has actually been a settlement that's been reached. And then you can always have those demand representation letters just going out immediately. It does not hurt you. So let's say this doesn't work, okay? And we're just still not getting any responses from passenger, from insured, from the counsel. And then we're gonna need to take some more aggressive measures. So now we're gonna head into litigation. But there is one last tip or trick to get reimbursement pre-litigation, and that is sometimes to send a final demand letter that includes a draft complaint against the insured. When the counsel or even the person who receives that complaint sees a draft attached to a demand letter, it sometimes makes them come to the table to settle, because they do want to avoid this lawsuit. They do feel that we're going to proceed forward. It's already been drafted. So this sometimes is a great tactic as well. So before we go diving into California litigation and medical payment reimbursement, it's always good to know the statute of limitations that we need to be aware of. And in our cases with MedPay, there's two that are very important. The first one is that there is a 2-year personal injury statute of limitation that runs from the date of the insured's accident. And this is important, not because the carrier needs to file anything, but it helps the carrier know if there's even a claim to be pursued. So for example, our insured gets in an accident on February 1st, 2023, today. They have until February 1st, 2025 to pursue their VI claim. During that time, we pay MedPay. Well, we have paid that MedPay because we have to through the policy. But if February 1st, 2025 comes and goes, and the insured never pursued any bodily injury claim against a third party, then we cannot pursue recovery of the MedPay. So this SOL actually can limit what claims we can even pursue. And then the second one is this 4-year breach of contract statute of limitation, which runs from the date of the breach. And this is the one that's going to really matter to us if the insured does decide to pursue the bodily injury claim. And then let's say a settlement has been reached and they're ignoring us. The carrier's recourse at that time is we can actually file suit under a breach of contract. As I stated, this is a contractual reimbursement. And it is from the date of the breach, which is usually going to be the date of the settlement, because every carrier has been sending out notices since the date of the accident. So the insured or the passenger, upon the settlement happening, should have provided us with recovery. Okay, so let's talk about the initial litigation process. So in California, you're going to be filing a summons and a complaint with the court. The jurisdiction that I usually try to file in is the county where the defendant lives. They cannot remove it. If you live in that county, then that it's a proper place to be to come in for a jurisdiction. Then you're going to have to hire a process server to get the complaint served, and this is where the process can become tricky because an insured is going to try to avoid that service. And what I usually try to do, and I'll give you a little story right after this, is I send a copy of the complaint to the insured's defense counsel. Well, and by defense counsel, they're a defendant, but really it was the plaintiff's counsel for the bodily injury claim. And it's a courtesy copy because it also puts them on notice that, hey, we're pursuing your client for MedPay reimbursement. And I hope that you told them about that in the numerous amounts of letters that I sent about our reimbursement rights. So what I've noticed in doing MedPay reimbursement litigation for some time now is that there are lots of plaintiffs' counsels in California. I mean, you could probably turn to your left and find a plaintiff's counsel. But sometimes there's, in certain areas, Northern California, Southern California, maybe middle of California, Central, there are plaintiffs' counsels that have a lot of these claims. And they either don't tell their own client that they have to pay back the medical payment reimbursement, or they really just don't care that, and they just think will go away. So once a complaint is served, then they have 30 to 40 days, depending on how service was effectuated, to respond to the complaint. Normally, an answer is going to be usually filed. And so, you know, I did have, and I briefly touched on this already, but sending that courtesy copy of the complaint to the plaintiff's attorney, and that's because there are many times where you will see a response from the plaintiff's attorney in pre-litigation saying, you're never going to sue us, go away, you're just bothering me. So once it's filed, I do send them a courtesy copy, maybe not to deal with this particular complaint that I filed, but it will show them that, hey, if we have future claims with you, we're here to stay. And then sometimes it also puts them on warning that, oh, if they forgot to tell their client something, that they're going to be in for a rude awakening. So just a quick story. I once had an insurance counsel call me and tell me that their insured was in their office screaming at them, and I could hear it on the phone because they had been just served with a complaint and they had no idea that medical payments had to be reimbursed. And plaintiff's counsel was desperately asking me to get this resolved right away because their client was planning on filing a complaint against them. And I simply just said, well, just pay us. So what do we need in a complaint? And as I said, we're going to need all the notices that were sent. When did we first put them on notice? You're going to want the policy with the declaration page. And sometimes some policies have endorsement pages. Hence, this is why notices are just so extremely important. In a complaint, the more we can show that we've given numerous notices and on what days, it's the better to show that the insured had this knowledge. Because this is also a breach of contract claim, there is also that requirement that we attach the contract to the complaint. So we do attach the policy with any of the endorsements, of course, always redacting any confidential information such as premiums that are being paid, stuff of that nature. Okay, who are the defendants? Well, it's anyone who has been paid medical payments by the carrier. It's super easy to understand why the policyholder was, if they were getting paid MedPay from the policy, then they're a defendant. But some are going to ask, well, what about if they are not the policyholder? And in Mercury Casualty Company versus Maloney, an automobile passenger was injured in an accident and received payments of medical bills under the medical payment provision of an automobile liability policy covering the driver of the car in which she was riding. The issue that was actually presented there is whether the passenger is obligated to reimburse the insurer as required under the policy for the amount of such payments from the proceeds she received in settling her claims against the other driver that was legally responsible for the accident. And in that particular case, the policy did provide a a pretty solid provision. It said, if payment is made under this coverage to or on behalf of any person, such person agrees to be reimbursed the company to the extent of such payment from the proceeds of any settlement or judgment that may result from the exercise of a rights of recovery of such person against any party that such person claims is responsible for the bodily injury to the person for which payments under the medical expense coverage has been made. A mouthful, I know. Well, what happened was the plaintiff, who wound up being the insurance company, filed an action against the passenger asserting claims for breach of contract and common count. And the passenger asserted that she required further medical care for her injuries and that her overall medical costs resulting from the accident greatly exceeded that $15,000 she received from the other driver. And the parties then agreed to submit the court based on stipulated facts and some motions. So after the hearing, the trial court granted passenger's motion, finding that because the passenger was not a party to the insurance policy, she was not contractually obligated to reimburse the insurers. But wait, the appellate court came in and actually reversed that trial court judgment. The appellate court actually held that as a third-party beneficiary of the automobile insurance policy, a passenger injured in an automobile accident was required to reimburse insurers for medical benefits that had been paid to her from the proceeds that she received in the settling of her claims against the driver who was actually legally responsible for the accident. The insurer had, of course, complied, right, with the contractual obligations under the policy, paid for the medical expenses, and pursuant to that reimbursement clause that was in the policy, the passenger was equally obligated to reimburse the insurer for those medical payments from the settlement that she received for the injuries. The court did conclude that the passenger, as a third-party beneficiary of the insurance policy, is required to comply with the conditions set forth in the insurance policy regarding medical expense benefits, and thus is obligated to reimburse the insured. And I will let you know that I have taken this actually to a bench trial last year regarding, it was a passenger again who kept fighting me on this, whether or not they really had to repay us. And we were successful thanks to this case, and they had to reimburse us. Okay, so let's talk about the complaint. We just talked about the facts that we're going to put into it, so let's talk about the causes of action. The first one we're going to be discussing is breach of contract, and we've talked about it in length, but the elements for this breach are that we have a written contract of automobile liability insurance, that the carrier performed all the conditions and all the promises that were required in that contract, which would be paying the medical payments, and that the defendants would breach that written contract by failing and refusing to hold in trust or to reimburse the monies back to the carrier. So as a result of that breach by the defendants in the obligations pursuant to that policy, that contract, there's now this money that's due and owing. We made demand on the insured for reimbursement, AKA those notices again. And but the defendant failed and refused and continues and fails to refuse to pay back the sum. So now defendants have breached that written contract and we have damages. The other cause of action that I use in these cases is called unjust enrichment. And this is just that the defendants received a use and benefit of the medical insurance benefits that were paid to them, that the defendants had requested and accepted those insurance benefits paid by the carrier with knowledge and the understanding that the defendants were entitled to receive those benefits based upon said defendant's status as a covered insured, that the defendants requested and accepted those benefits, and that they were aware that they had to reimburse. Again, this is why I like to mention that giving notices to everyone involved in that accident is just such a crucial part of MedPay reimbursement. Furthermore, the defendants failed or refused to hold in trust and reimburse monies to the plaintiff that have been unjustly enriched at the expense of the carrier. And then finally, that the defendants are under an obligation to pay the carrier all those amounts that they have been unjustly enriched by. And now we're on polling question number 2. A passenger can be a defendant in a MedPay reimbursement complaint. True or false? Give you guys just a little bit of time. All right, with 90% of the vote in, it is true. Oh, there we go. Okay, so I want to briefly discuss what if the insured doesn't respond to that complaint and what would happen. So they are defaulted, and what you do is you file this request for a default with the court, but that's not it. You then have to submit a default judgment packet. Every court in California has different requirements when it comes to how the default judgment packet will work. Normally, it is like a trial by declaration, so we do need to submit a declaration from the attorney attesting to certain facts. We will need a declaration from the carrier attesting to the facts that there was a policy issued, that there was a medical payment coverage that was chosen, that there was medical payments that were made due to an accident that was reported, and how much were the payments and to whom. The declaration will also include that the notices were sent with the notices attached and that the payment was just never received from the defendant. Then you also need to have proof that there was a settlement. I usually try to obtain a declaration from the adverse carrier, and all they have to do is to attest that there was a third-party settlement. They do not need to disclose anything further than that. So if they're claiming it's a confidential settlement, that's fine. All we just need them to say is that there was a settlement that was reached. Now, other courts are different, and sometimes they'll require what's called a prove-up hearing, which is like a mini trial. Normally, I actually need my carrier present or an adjuster present because I need to put them up on the stand to attest to the facts that we just finished discussing. And once the court is satisfied, they will enter that judgment. Just briefly, once a judgment is awarded in California, it is good for 10 years, and you actually can continuously keep renewing it for 10 years. To collect on those judgments, I do recommend a collection agency. They're the company to handle those. So what if the answer is filed? Well, then you're entering what's known as the discovery phase. And before we get into that, I did want to mention that I've seen the answer filed 2 ways. The defendant themselves can file it, which means they're representing themselves. It's also known as in pro per. Or you can actually have, of course, the attorney who represented them in the bodily injury case is what I typically see. I will say having the latter happen is easier to get to a resolution, only because an in pro per defendant is sometimes difficult because they don't understand what the litigation process is. But let's get back to discovery. So this is the stage where we get to ask the other party questions. And the purpose of discovery is to kind of take the game element out of trial prep by enabling parties to obtain the evidence necessary to evaluate and resolve their dispute beforehand. It's about preserving evidence for trial, providing a basis for pretrial motions. It's narrowing the issues for trial. It does promote settlement, and it does avoid those surprises at trial. I know you guys see that on shows a lot, but that's not really how it works. And discovery is not filed with the court. This is just an exchange of information if a discovery issue does arise. Okay, and there are several different types of written discovery. And it can depend on if your case is limited or unlimited. Under 25,000 is limited, above 25,000 is unlimited. So there's written discovery known as interrogatories, foreman specials, requests for admissions, requests for production. You can also do inspection demands. Those typically aren't in MedPay. You can do physical and mental examinations. Again, not in MedPay a lot. There are depositions, and depositions can be of the parties, the non-party witnesses, person most knowledgeable, person most qualified. But again, as it relates to what we're doing and talking about today, we normally are going to be doing a brief set of written discovery and perhaps the deposition of the defendants. And sometimes I will say that a strategy is to bombard the defense with written discovery to see if they would rather just settle than spend time answering the question. And this has really worked well for me in the past. The other tactic I tend to use is to send a deposition notice to the defendant. The time and cost to prepare one for a deposition is costly and time consuming, so this will also push the defendants into settlement. So usually for these cases, I want to send out that first set of discovery right away, and that's with a request for admission and a form interrogatory. And each is going to be tailored to the person in that accident. So let's focus in on just the request for admissions briefly. It again does depend if you're the policyholder or not the policyholder. So I usually ask a policyholder to admit that they had a policy, what their policy number is, that they received a copy of the policy, and then for both a policyholder or a non-policyholder, I do want to ask: were they involved in a car accident? Did they get paid MedPay from the carrier? Did they settle that claim and get a third-party settlement? So again, it really will depend on who it is I'm asking questions of. Again, also with the policyholder, I do ask the genuineness of documents, which is the policy. I will attach that and the declaration pages, sometimes the application with their signature. So it prevents them from saying in the future that they never knew about the policy, or they never knew that they weren't, that they were going to have to pay back something. Okay, and then the other set of initial discovery is form interrogatories. These are on a court form that's been approved by the court. Here, I usually will ask the general background questions about themselves and what their contentions are as to why they believe nothing is owed. There's also a great section on breach of contract questions, and it allows me to see if they're claiming that for some reason they thought the contract was vague and ambiguous, and to what terms. So common defenses. We have the made whole, so we've kind of talked about the litigation process, we've talked about discovery, but let's talk about the made whole doctrine and the common fund doctrine. And there is one more. And this is a unique one. So it's report you to the news outlets. I normally get these comments from a defendant that's representing themselves. They will say, well, I'm going to contact my local paper or news stations. I'm going to tell them my own insurance company is coming after me. Usually those never actually happen. And for me personally, in my career of handling these claims, I've never actually had that occur. Why I think they do that, why do I think that they do that? It's really because they're mad, they're upset, they have to pay back money. But reality, it's not some groundbreaking newsworthy thing that's occurring. So for the most part, it's just a veiled threat. Now, the made whole doctrine, everyone's favorite doctrine in California, and a favorite by plaintiff's counsel. So the made whole doctrine prevents an insurer from recovering any third-party funds paid to the insured until the insured has been fully compensated for his or her injuries. And the made whole was extended to MedPay subrogation in 2005. And this comes from the decision in 21st Century Insurance Company versus Superior Court Quintana, which I'm going to be discussing shortly. Now, there are ways to defeat the made whole, one being that the insurance policy has a provision that permits recovery even if the insured is not made whole. But those policy provisions, you have to have clear and specific language. And also in California, the carrier must cooperate and assist the insured in the recovery effort. And California, I will say, is very strict when it comes to eliminating the made whole doctrine. I did provide some exceptions to the made whole. This is an example here of the language that's deemed insufficient to overcome made whole. It's just not clear and concise. Versus this next slide, I will say, is where it's deemed sufficient to overcome made whole doctrine. This is one where it's more specific, more concise. But let's go into 21st Century Insurance Company versus the Superior Court, Quintana. So in 2009, 21st Century stated that the carrier has a right to seek repayment back out of any third-party recovery received by the insured. They had to do so through contractual reimbursement rights against the insured because, again, in California, you are not allowed to assert subrogation claims directly against the third-party tortfeasor because personal injury claims are not assignable. So in this case, the insured, which was named Quintana, was injured in a car accident. So pursuant to the no-fault MedPay coverage provision in Quintana's auto insurance policy, 21st Century paid her a full $1,000 of her benefit. She then instituted her own BI claim, and in that action, she incurred attorney's fees of roughly around $2,000, and she settled her claim for only $6,000. She also had stated that $6,000 would have made her fully whole. Well, you know what happens. 21st Century goes and seeks reimbursement of that $1,000. And she contends, Quintana will contend that she was not made whole because after deducting about the $2,000 from her recovery, she didn't get the full $6,000 that would have made her whole. But what happened was that the court had ruled that I apologize. 21st Century actually conceded that its reimbursement claim should be reduced in consideration of the legal expenses incurred by the insured. However, 21st Century did contend that any offset was governed by the common fund doctrine, which we're about to talk about. Because under that common fund rule, a party who benefits from another party's efforts to obtain a recovery must bear a pro rata share. So 21st Century conceded that they wouldn't get the full 1,000 because they had to reduce by common fund. And the California Supreme Court did agree with 21st Century. However, they had a very different rationale. They said that their underlying its decision, it's tied to the unique nature of MedPay coverage and auto policies. First, because again, personal injury claims are not assignable. A MedPay insurer can't proceed on its own behalf, right? And can't intervene. So the court reasoned that the insurer cannot voluntarily elect to bear its own litigation costs. And then second, just because MedPay insurance is a no-fault coverage which pays the insured's reasonable and necessary medical expenses due to the accident up to a relatively low dollar limit in exchange for relatively low premium. So again, there tends to be a lot of confusion as to the made whole doctrine and attorney's fees. And as I mentioned, made whole does not include liability for all the attorney's fees that the insured must pay. So this is just a brief example. The carrier pays the insured $1,000 in MedPay. The third party recovery is $6,000. Her total damages, what she needs to be made whole. The insured's attorney's fees is $2,000, leaving a net recovery of only $4,000. We, the carrier, seek reimbursement of $1,000. The insured argues her damages, including attorney's fees, are $8,000, and her recovery is only $6,000. Therefore, she's not made whole. Again, fees are not included as part of the insured's damages, so in fact, the insured is made whole. And our last polling question, true or false, the made whole doctrine applies to attorney's fees in MedPay reimbursement. Give you guys just a second. All right, with 85% of the vote in, we have it is false. Okay. So the common fund doctrine is also known as the pro rata rule, and it says that a litigant who creates, discovers, increases, or preserves a fund to which others also have a claim is entitled to recover litigation costs and attorney's fees from that fund. That doctrine is an equitable doctrine designed to prevent unjust enrichment. So this is always going to come into play. The rule provides a separate and independent limitation on an insurer's reimbursement right. Typically, you're going to be reducing the lien amount by the attorney's fee percentage that the plaintiff attorney is charging. That is like the common practice that happens in California. Typically, it's about a 1/3 reduction, but I've also seen 40 to 50%. But you always need to look at the recovery and reduce by the common fund. You will not get a full MedPay reimbursement recovery if an attorney has been involved. So now let's discuss some really important topics, and one that I'm sure has been on all your minds throughout this presentation, which is show me the money. How do we get these recoveries? Well, as I said, I'm focused in on California, and so what I've noticed is these large plaintiffs firms that I'm dealing with. So some firms it takes about 2 to 3 cases for them to really understand that you're not going to go anywhere. Some firms you'll need to play this hardball. So if the firm is ignoring you, then I bombard them with every case I have with the firm, and I start to just shoot off emails to them and for each one of the cases. So they're getting like one email after another, just filling their inbox. I also will look up the firm's website and then email every attorney I can in order to get some attention. I also will simply just pick up the phone and I try to just obtain an email address, or I have my paralegal do it. And I also try to let them know I'm going to continue to be calling you. I just want to be that thorn in their side. So one of the better ones that I've found, in that not a lot of people know, is at the California State Bar website, and there's that link on this PowerPoint. Actually, you can obtain email addresses if the attorney has put their email address on the website. So I go there, I get their email address, I send them a notice of representation, I let them know that we're contemplating maybe taking this to court, maybe taking this to small claims court. And a lot of times they will finally respond. So I briefly want to be able to touch on this double recovery strategy that I've used before. It's called the AHLBORN formula. So what it was that we had a, MedPay, as you know, we have to seek recovery. MedPay insurers must seek recovery from personal injury claims through contractual reimbursement rights. And we all know that the made whole rule is the common law principle that limits the insurer's rights in situations where the insured had not recovered his or her entire debt. And in the case of the Hartford Accident and Indemnity Company versus Groteman, the court determined that the insurer had a valid and enforceable right to be reimbursed from the totality of the proceeds received by the defendant rather than restricted to medical payment proceeds. And the rights of the insurer are limited, as we all know, by the common fund and made whole. But simply because an insurer's rights to be reimbursed may be limited by the made whole rule, it does not obviate the principle that an insured is prevented from receiving a double recovery, with the financial responsibility being placed on the tortfeasor. So a carrier is entitled to all amounts that are recovered from the tortfeasor, which are considered a double recovery. So there was a case, and it was called the Arkansas Department of Health and Human Services versus AHLBORN, which involved a Medicaid's right of reimbursement. So the case is actually an instructive way of how to calculate a portion of a settlement that does not allocate which portion of the settlement is attributable to past medical expenses. Numerous courts have since accepted this formula as an acceptable method of approximating the amount of medical expenses to be reimbursed. So in a settlement that does not allocate between medical past medical expenses, and other damages, the ratio of the settlement to the total of the claim when applied to the total payments to the beneficiary is an acceptable approximation for the amount of the medical expenses. So in this case, it was a Medicaid recipient who had suffered some injuries, and the case settled for $550,000, and it wasn't allocated. So that's a really important part. If it wasn't allocated, this is where we can use this formula. So the Department of Health Services had imposed a lien against the settlement proceeds, and it represented the amount of past medical expenses. So the U.S. Supreme Court actually held that Medicaid could only assert a lien on a portion of a settlement that was attributable to the past medical expenses. And they stipulated what the entire claim was worth, and then they figured out through calculations the amount that the settlement that was actually settled for was approximately 1/6 of the sum. So the health department was entitled to reimbursement of 1/6 of the medical payments that were incurred. And how does that work? Let's go through this brief example. So the total value of the plaintiff's claim is $2 million, and the case settled for $500,000. Now, the key part is that the settlement was not allocated among the various categories of damages. We have paid $100,000 in past medical expenses. So if we look at the settlement, it amounted to 1/4 of the sum, so 25%. 500,000 is 1/4 of 2 million. Therefore, the carrier is entitled to reimbursement of 1/4 of the medical payments incurred and made, which is $25,000. Now, the last part of this is contribution to the common fund. And we say the pro rata share of the attorney's fees, let's say it would be 35% of the $25,000, which entitles the carrier in the end to the $16,250 in reimbursement. Now, I have had some attorneys who receive this email about my theory, and they just don't buy it, or more often than not, they note that the amount, but more often than not, they're going to actually see that I've added all this case law, and that's just enough for them to just send the money outright. And it's mainly because they realize I'm going to fight this, and they are realizing this isn't a large dollar amount we're fighting over. Now, I know we've run out of time, so this is just quickly about MedPay in other states. As you can see, some, like Colorado, prohibit it altogether. Some prohibit payment some permit it through direct subro. Some are going to require you have subrogation language. It's going to, again, depend heavily on the applicable state laws. And this is just about, in other states, how you can go about settling MedPay. There's different options. You can settle it with the third party. You can settle it in arbitration, intervention, notices of lien. It's case law dependent, state law dependent. So I know I covered a lot of information in a short amount of time. I could have probably taken 2 hours to go through this. We do have, though, a great book that covers automobile insurance subrogation, including MedPay, not only just in California, but in all 50 states, as well as it provides you with general information about just auto subro in general. It is a wonderful resource, and it's available through the Juris publication website shown on the screen, as well as at our own website. So let's get reimbursed. If you have any questions, I will answer them via email. I appreciate your time. I hope everyone stays warm. I think it's chilly for everyone across the country. Warm and safe, and enjoy the rest of your week. Thank you so much.